thank you everyone for joining us today at this webinar. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we're going to spend some time to discuss the E-2 visa requirements and considerations for the renewal of the E-2 visa. So just a few things before we get started. Some of you may know that the firm was actually founded on an E-2 visa 10 years ago. The founder of the firm, Ian Scott, applied for an E-2 visa to come to the United States to establish Scott Legal. And the firm has successfully renewed its E-2 visa as well. So this definitely gives us very deep familiarity and expertise with E-2 visas in particular. So Scott Legal is a full-service immigration law firm, but we do focus primarily on E-2 visas. We have processed hundreds and hundreds of them, and we process many E-2 visas that are also considered higher risk with a lower investment amount. For example, we have processed at diverse consulates around the world, but our primary two consulates that we process most frequently are Toronto and London. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different topics. And at the end of this webinar, we'll be sending out a few things. So first, we will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a comprehensive guide to the E-2 visa that you can use as a resource. We will also send you a link that you can follow to where you can sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we do regularly upload a variety of immigration law related videos. Finally, we'll send you a link that you can follow to set up a consultation with one of our experienced lawyers should you wish to discuss your case further. As for today's panelists, we're very lucky to have Michaela Romesser, who is a senior associate of the firm, who has a leading expertise in processing a wide variety of E-2 visa cases. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will start the presentation. So let's start with an overview of the E-2 visa rules and regulations. So as many of you may know, the E-2 visa is a non-immigrant visa for investors who are coming to seek to come to the US to develop and direct a US enterprise that they have invested in. Now, the E-2 visa won't necessarily automatically lead to a green card, but it is possible for the E-2 visa holder to continue extending the visa indefinitely as long as the applicant continues to meet the E-2 requirements. Now, there are 2 options for obtaining an E-2 visa. The first option is to purchase an existing business in the United States. The other option is for the applicant to start up a new enterprise in the United States from scratch. Now, in order to qualify for the E-2 visa, this E-2 visa is not open to all nationalities. So in order to qualify for the E-2 visa, it is important that there must be a treaty between the US and the foreign country of which the applicant is a national. And if you can Google the list of treaty countries for the E-2 visa, and you can see that numerous countries from Europe, Africa, Asia, Latin America, and the Middle East are included in the treaty country list. So this is definitely an option that is available for a wide variety of foreign nationals. Now, the last thing to note is how long is the validity of the E-2 visa? And really, this depends on the nationality of the applicant. And the way that you can figure this out is to Google reciprocity schedule at the US Department of State. And according to the reciprocity schedule, there is a variety of length of the visas that are offered for the E-2 category. So for example, for Canadian nationals, for example, you could get a visa, E-2 visa that is valid for up to 5 years, as opposed to some other countries which may have shorter validity times. So in some circumstances, the visa could be as short as 3 months. Now, there is a distinction between the validity of the visa and the validity of the period of stay that you are granted when you actually come into the United States to develop your business on the E-2 visa. So that is the distinction between an E-2 visa validity and the length of the E-2 status that you get when you actually come into the United States. So let's say that your visa stamp is only valid for 3 months. However, if you come in to the United States at entry, you are given 2 years to stay in the United States and develop your business. So there is definitely a distinction between the visa validity period and the validity of the authorized stay that you get when you come in to the United States. And even if you do have a 5-year visa, that does not mean that when you come in, you can just, stay for the entire period of 5 years. You will be only given 2 years at a time at each entry to develop and direct your business. So definitely important to always be checking your I-94 when you enter the United States, because that governs the period of authorized stay in the United States. All right, so then let's move on, excuse me, and talk a little bit about the E-2 visa requirements in more detail. So the first requirement, you must be a national of a treaty country. I have already discussed a little bit about that in the previous slide. There must be a treaty between the foreign country and the United States in order for the applicant to be able to participate in the E-2 program. The second requirement is that the applicant must make an investment. So what does investment mean, right? So if you are purchasing a business, that is simple. The money that you pay the seller to purchase the business is considered the investment. Now, what about if you're starting a new business, starting a new startup from scratch? Investment here means money that is put at risk towards setting up the business. So this means money that was actually spent on tangible things. And so, for example, if someone applies to the E-2 visa and say, "Oh, I transferred all of this money from my personal account to my E-2 business account, and the money is just sitting there in the bank account," unfortunately, that is not going to be considered as money spent at risk, money placed at risk, which is required for that to count as investment. So spending can be on a variety of things. For example, if you hire legal services to prepare for the E-2 visa, that can also count as spending. If you execute a business location lease, a commercial lease for your business office, that can also be part of the spending. And if you spend money on setting up accounting structures, setting up, the legal structure for your business, that also can be, included in money placed at risk. Now, the other thing to think about is what is the source of the funds that you use towards setting up your business. Now, really, the requirement is that the source must be legitimate, right? And that it must be visible where you earn the money from. So if it is from personal savings, you can, demonstrate to the government that you obtained a particular amount through your employment. It can also be a gift from someone in that case, we also want to tell the government where the gifter earned that money from. So, for example, if the gifter, sold property or obtained employment income, and from that income provided you the gift, you will also provide the source of funds of where that gifter earned the money from. Sale of a house, that is also another way. You can provide a legitimate source of funds. You would provide a copy of the sales agreement, showing that you own the house and then you sold it, and then you use those proceeds to fund your business investment. It can also be a loan. Now, the requirement for the loan is that the loan must either be unsecured or if it is secured by something, it cannot be secured by the assets of the E-2 business or to the E-2 business itself. So, for example, if you own, your own house and then you take out a loan, with, security of your house, then that's unrelated to the assets of the E-2 business that you're setting up. So that can be used as a source of funds. Now, the other requirement is that the investment amount must be substantial. And we will talk a little bit more detail on what really means that the investment is of a substantial amount. But that typically means that everything that you need to spend in order to set up a legitimate business must have been spent. And if you're, purchasing a business, then the entire purchase price would be a substantial investment. Now, what are some typical E-2 expenditures? So expenditures here mean that when you are setting up a startup in the United States, when you are setting up a new business, what are some of the typical areas that you can spend money on to prove that you have placed substantial funds at risk to meet the investment requirement? This can include things like inventory, equipment that is required for a business, and sometimes if you're setting up a business like a consulting firm, like computer equipment can also be included in this calculus. Website, if you are setting up a website to market your business to earn clients, that can also be part of the cost that you can put in the setup. Expenditures, office supplies, if that is relevant to your business. Rent, I already talked about this. If you're setting up a commercial business space, the security deposit and any rent that you pay, can be included in money placed at risk. Now, you can only include the rent up to the point that you actually pay the rent. So any future payments for the rent, you can't really include that when you're applying for the visa. Now, one thing you can do though is choose to prepay a portion of the rent for the whole year or for 6 months, for example, if you want to really show that you have committed to the business. And that is actually a common strategy that we see when clients want to increase the investment amount to show that commitment. Marketing cost is also a common expenditure. You can hire a marketing firm to set up a PR campaign, or you can purchase ads for your business services. All of these things can be included as part of your investment. Any costs that you incur when you're actually setting up the legal entity for the business, and I've mentioned that before, can be included. Now, one difference between putting money at risk when you're starting a business versus when you're purchasing an existing business is the option to use an escrow when you're actually purchasing a business. The escrow option is not available when you are actually setting up a business, but when you're purchasing an existing business, what you can do is set up an escrow arrangement where you agree to put the entire purchase price to a third-party escrow account with the sole condition that the money will be released if you are approved for the E-2 visa. So this is kind of a protection that some clients may want to institute if they are not sure if they would be, approved for the E-2 visa or not. And sometimes they don't want to go forward if the E-2 visa is denied, right? So in that case, it is possible to use an escrow arrangement to hedge against that risk. But the thing to note is that the only condition for the release of the funds will be approval of the E-2 visa. So if there are any other conditions to consummating the sale that will negatively affect your E-2 visa case, the only condition should be the approval of the E-2 visa, and that's only the only circumstances where an escrow account is used for the E-2 investment. All right, so the third requirement is that the business cannot be marginal, and marginality is a very important requirement. The government doesn't want to see a solo, kind of a sole practitioner kind of deal. The US government wants to see that the business is actually a real and operating business, and importantly, will be earning enough revenues to not only support the investor and his or her family, but also to be able to hire US workers to do the job. And the investor is really, and this is also important because the investor is expected to be kind of the CEO, the person who is directing and developing the business, not necessarily providing direct services. So really, the government is expecting that the E-2 visa holder will be hiring US employees to perform the actual work on the ground. So the revenue generation potential will be very important. When you're applying for the initial E-2 visa, you would provide a business plan, a very detailed business plan that shows the revenue generation potential. And if you're renewing, the E-2 visa, one of the things that will be an important consideration is what was the revenue generation scale of the business in the past couple of years before you apply for the renewal. All right. So the other requirement is that the business must be real and operating. And by real and operating, that means either the business is already taking revenue or the business will be ready to start operating as soon as the E-2 visa is granted and the person enters the United States. So this is really important, especially if you're starting up a new business, right? So if it looks like the business is not ready to open its doors as soon as you enter the United States on the E-2 visa, that could negatively impact your E-2 visa application. So that practically it means everything that you need to operate the business must already been set up by the time you apply for the visa. So for example, if you are going to have a physical office, you would show that you have signed a commercial lease for your business location. You would have already established the business entity. You would have already created the company website. And if you can show that you already have contracts with customers in the United States, that could be a very good way to meet the real and operating requirement by showing that you're pretty much ready to start operations. Licenses. Now, one thing is if you need a license to operate in that particular industry, then you must show that you have already acquired the license before you apply for the visa, because that is a part of what you need to, start operating your business. So if you don't have that license, or if you cannot show that you will have this license in a very short period after you enter the United States, that could also be a risk factor. All right, so the fifth requirement is that the applicant must be coming in solely to develop and direct the E-2 enterprise. And I've mentioned that a little bit earlier in the context of employees, right? So that means the role that you must play in the United States in your company is primarily executive, primarily, managing the business direction, as opposed to providing direct services. So this can be, an issue, especially if you're kind of, planning to run something like a consulting firm where the officer may be worried that you're just coming in to become sort of a sole practitioner where you're the one who's providing services, as opposed to hiring employees to do the work. So that can be a distinction to be mindful of when you're applying for the E-2 visa. The sixth requirement that we'll talk about is ownership, and it is very important ownership requirement that the person who is applying for the E-2 visa as a principal investor must own at least 50% of the stock, the shares of the E-2 company. So that is a very important requirement to keep in mind of. And finally, the requirement is that the E-2 visa is a non-immigrant visa, which means the applicant must be able to convince the officer that they have the intent to return to their home country upon the expiration of the E-2 visa, upon the termination of their business. So their intention to come in and develop and direct enterprise must be a temporary one. And usually that is satisfied by a signed statement by the applicant, confirming that their intention is to, come in on a temporary basis to run the business. But in other cases where, for example, the applicant has a immigrant petition pending, for example, those can, provide additional risks in terms of this immigrant intent question. All right. So now let's focus a little bit on the substantiality requirement that I have mentioned a little bit earlier at the overview. So the requirement is that the investor must invest a substantial amount of money. There is no minimum dollar value that the government imposes as a term of the regulation or the law. However, there are some general rules of thumb on how much money is usually expected that an applicant would spend. That is enough to show that they are indeed committed to coming in and setting up this business. And really the minimum amount of investment that can be considered as substantial depends on the type of business that the applicant is proposing to set up. It can also depend on where you apply in the world, as different consulates may have different standards on what they think is a substantial investment and what is not. Like, for example, consulates in Japan, for example, is known to really be used to seeing very high investment amounts. So anything under $100,000, for example, could be seen as just too low to qualify for the substantiality requirements. So definitely that is why it is good to work with a law firm that has had various experiences with consulates around the world and can provide you guidance on such nuances and local differences. Also could depend on the examiner himself or herself, right? So each examiner can come in with different sets of expectations about how much money usually is required to successfully set up a business of that type. And so, for example, like, if you're and going more on the type of business, if you're setting up a small consulting firm, for example, with only 2 or 3 employees, then maybe the cost may not be as high as compared to a situation where you're setting up a retail business or a restaurant or a manufacturing business, which can involve heavy machinery and equipment, expensive equipment, and those costs can go a lot higher. Also, what is a factor is the overall strength of your case. So even if you have a relatively lower investment amount, if you can show that the business is actually ready to be real and operating by showing many contracts with potential clients in the United States, or if the entity has already started earning revenues and already has an employee. So if you're stronger in other aspects such as marginality, real and operating, and that can actually help in the substantiality area as well, by proving that your business is otherwise going to be thriving, then maybe the officer can rely on that and think, oh, okay, maybe this is a substantial amount of investment. Considering the type of business and considering the revenue generation potential that has been determined. So when we're talking about substantiality, it is also important to consider the proportionality test, and that is related to when you're starting up a new business. How much money have you invested, as opposed to what are the usual costs to establish that type of business. And a good rule of thumb to think about is if you are setting up a business that is smaller in scope, a smaller business, then typically the government will expect that you have spent 100% of what is required to set up that type of business, as opposed to a 10 million manufacturing firm, for example. If you put in 1 million and it is required to have 10 million to fully establish a type of business, then you can go get away with a smaller percentage. But for smaller businesses, you would typically be expected to have spent 100% of what's required. Buying a business, purchase price versus fair market value. So the substantiality analysis when you're buying a business relates to what is the fair market value, right? So if you bought a business in the open market, typically that will be considered the substantial investment that is required to buy that business because you bought it in the open market. The real risk factor is if you buy the business through an acquaintance or someone so not in the open market, but through more personal connections, then you may want to provide additional support that the business price that you paid is in fact the fair market value of that business and you have paid everything. So in that case, an independent letter analysis letter from a CPA, certified public accountant, could be helpful in providing that more evidence that the purchase price that you paid was fair. Some other notes to make before I move on to the next slide. Franchises can be a good option for E-2 visas because first of all, any fees that you pay in relation to the franchise fee, setting up the franchise, getting it approved, that can also be included in your startup expenses. But also because franchises give the founder of the business resources to market the business and kind of guidance on the business strategy and things like that. So it could be good to towards providing evidence under marginality or things like that, because you do get that support. common good and bad E-2 visa expenditures. So not all expenditures would be a great thing to include in your total investment amount. There are certain things that are risky. For example, like if you meet clients and you travel to meet clients and you try to charge, you try to include the airline ticket fee that you pay to, in your trip to meet clients. And typically those kinds of travel expenses are not very good to include in your total E-2 investment amount. In a similar logic, things like meals, entertainment costs, things like that would not really be, a good type of expense to include in your E-2 investment, even if it's related to setting up your business. Other types of risky expenditures can be things like vehicles. If you buy a car, but if there is no real not a strong link between your business purpose and the car, and if you're only going to use the car to go to and from your workplace, then that's likely not going to be considered as a valid E-2 investment. Usually things like marketing, things that I've mentioned before, setting up, veritable business costs of setting up the business structure, and accounting fees for things like that. Employee payments to employees can be included, a commercial lease, equipment, things like that. Those kind of, the normal, bread and butter business expenditures that will be necessary to set up a business. Those things are usually good. And the examples that I cited would not be. All right. So the other topic that we get a lot, the question that we get a lot is, do I have to hire employees before applying for the E-2 visa? Now, do you have to hire US employees for your business as a whole? And the answer to that is yes. At some point, you do need to hire US employees because that is really the purpose and driving force of the E-2 visa program. And really goes straight to the marginality requirement. The government is intending this visa to be, for people who come in and operate a business that will generate jobs for U.S. workers, and really is not intended for businesses that only support the investor and his or her family. So at the time of application, the applicant must be able to show that the E-2 business has either the present capacity or the future capacity to generate enough income to provide more than a minimal living for yourself and your family. So this means, in more practical terms, that the business must have the potential to hire employees in the next 5 years, ideally, and we recommend at least 3 to 4 full-time W-2 employees. Now, W-2 employees versus 1099 workers in some industries, for example, in construction, you will see industry practices where it is normal to, rely on 1099 workers. So in those kinds of specific circumstances, it could be okay if you can show that you've hired a, substantial amount of 1099 workers. However, in all situations, regular W-2 employees, full-time W-2 employees are preferred, and that is what we recommend when you're setting up an E-2 business or when you're applying for renewal. It would be very highly recommended to have W-2 employees by the time you apply, well, for the renewal. Now, if you're actually initially applying for your first E-2 visa, then you don't need to show that you already have employees, because the plan is that you will come to the United States and develop and direct your enterprise and eventually hire those employees. So in that case, when you're applying for the initial E-2 visa, you don't need to already have employees. However, you must be able to convince the officer that you will hire employees when you get to the United States. So how do you prove that you will hire employees? As I mentioned just now, if you are applying with a new business, a new E-2 visa, then you will provide a very well-researched and compelling business plan that shows the 5-year hiring projections, showing that who you're going to hire, when you're going to hire them, and what role those employees are going to play in the next 5 years. If you are applying for a renewal, for example, for the E-2 visa, and the enterprise is already operating, then the key documents to provide are the W-2s, form W-2s that will show that you have hired those employees, pay stubs for the employees, and tax returns for the business showing the historical revenue generation of the business in the past few years before you apply for the visa, showing that your business is non-marginal. All right. So business plan considerations. Let's talk a little bit more about the business plan. Do you need a business plan? So if you're applying for the E-2 visa with a new business that you're starting up, then yeah, definitely including a business plan is highly recommended because of this marginality consideration that I mentioned before, because you need to convince the officer that your business will generate enough revenues to not only provide a living for you and your family, but also to maintain full-time jobs for US workers. Now, let's say you're purchasing an existing business. And so it really depends on how was the performance of this existing business. So if this existing business has a track record of having multiple employees, very strong financials, and if you can show that with historic tax returns and W-2s of that business that you purchased, then maybe you don't need a business plan. However, in some cases, the performance of the existing business is not that great. So if you want to mitigate marginality risks, then it could be a good idea to include a business plan to, show the government like why, under your leadership, the company will hire more workers. The company will, generate higher levels of revenue than the historic data, or if the historic data is lacking, for example. So really, it is a case by case determination on whether you need a business plan and what the business plan will say. So let's talk a little bit more about the contents of what the business plan should contain. So we recommend the business plan start with an executive summary, providing a concise overview of who you are, what you plan to do, and who do you provide your services to, or who do you, sell your products to if you are in that business. Market analysis and research could also be a helpful addition to the business plan, providing more context about the industry in which you operate and what are the opportunities that you see in operating your business in that field. Marketing plan is also a key part of a business plan. You want to be able to show the officer that you have some methods set up to generate clients, generate demand for your products or services. A personnel plan, as I mentioned before, is very important to meet the marginality requirement. We would recommend adding 5 years of hiring projections, a table where you list out the types of employees that you're going to hire, when you're going to hire them, and how much salary you're going to provide those employees. And really, the salaries that you project to pay to these employees must really also be in line with the revenue generation that you're projecting, right? Because you must have enough, income in order to be able to support the jobs of the employees that you project. So it is important to really have a comprehensive and well-researched financial plan that really lines up, in all of these different aspects. Right. So though the comprehensive financial plan would include things like revenue projections and also a description of the assumptions on how you calculated those revenues, cash flow projections, how you're going to, maintain the cash that's required to maintain business operations, and also include a projected balance sheet for the 5 years, showing how the business is going to grow in value over the years that you manage it. Do I need to hire a professional to prepare a business plan? Now that, really depends on, the skills of the, applicant who is preparing the application. Typically, I find practically that it could be helpful to hire a professional. Now, we also provide professional business plan, drafting services based on the information that the client provides and we will provide guidance on which content to bolster, and kind of provide guidance on what we think regards to the financial projections with respect to marginality and other requirements. So definitely it will be a good idea to get professional help in preparing comprehensive and well-researched business plan that can convince the US CIS officer of the health of your business in the future. All right, so now then I will turn it over to Michaela, and she will take us on the other nuanced topics.
Thank you so much, Jiyae. Yeah, so let's discuss some E-2 visa developments and recent adjudication trends. So first, let's discuss investment purchases in the US. And so here, we get this question often from, potential clients. Can I kind of purchase property in the US as an investment? Let's say that someone wants to purchase a property like an apartment or a house for $1 to $3 million and then rent it out. And, could this qualify and can I get an E-2 visa if I make this investment in this particular property? So the answer here is unfortunately not. So as Jiyae discussed, the investment portion, kind of like how much money you invest, is just one kind of portion of the E-2 visa. And so the other things you would have to show for the E-2 visa are, for example, the ability to hire employees. So if you only purchase one property, you rent it out. Like even if you purchase under LLC, the company would probably not have any employees. Another thing you have to show is that the E-2 company will be real and operating enterprise. So again, like this requirement, if you only have one property, could not really be met. So here, if this is something you are interested in and you are planning to purchase real estate property in the US, how it could work and how you could qualify for an E-2 visa is that, let's say you set up an entity in the US and you purchase multiple properties, really kind of like you would be doing this on kind of like large scale. So let's say, you would have, or the LLC would have, 10, 20 properties or more. Then, the company could provide property management services and, then you would need obvious employees to provide those. So then, this type of business could qualify for an E-2. But if the plan is to really kind of purchase, 1 to 3 properties and just rent it out and collect rent, that would not qualify for an E-2. So now let's discuss administrative processing and what this means. When you apply for an E-2 visa at a consulate, you will have to have an interview. So the US consulate will never approve initial E-2 visa application without an interview. This is kind of one difference between applying for an E-2 visa at a consulate versus applying with the USCIS. So if you apply with the USCIS, and you could only apply with the USCIS if you are already in the US on some other non-immigrant status, you could potentially file a change of status petition with USCIS. And in that case, you would only be mailing the E-2 petition to USCIS, and then there is no interview with USCIS, and USCIS would just kind of, make a decision on that application. If you are applying at a US consulate abroad, and this is, really what most people do, just because, if you apply at a consulate, you get a visa. This allows you to travel in and out the US. If you apply with the USCIS, that kind of only gives you a status in the US. And if you leave the US, you would need the visa anyway. But at the end of the interview at a US consulate, the consular officer, can make basically 3 decisions. So the consular officer can either approve the E-2 visa right away. So in this case, they would tell you at the end of the interview, they would tell you, we are approving the E-2 visa, leave the passport here, you would leave your passport, and then in approximately 1 to 2 weeks, they would, issue the E-2 visa in the passport and mail you the passport back, or you could also pick up the passport. So that's one possible decision. The second possible decision is, that the officer would conclude that, you are not meeting the E-2 visa requirements, and they would tell you that they are denying the E-2 visa application. So in that case, they would issue you a notice. It's called 214B notice. And usually they would kind of write a short explanation, as to, or they would tell you as to why you didn't qualify for the E-2. And then the third possible outcome is the administrative processing. So in this case, at the end of the interview, the officer would let you know that, something in the sense that, it looks that you are meeting the E-2 visa requirements, but the case has to go through additional kind of governmental review. And then what it would mean is that the case would go through an administrative processing. And, really what this means is that the government just needs some additional time to either, do some additional like background check, or just kind of some additional time to make a final decision on the application. Sometimes as part of the administrative processing, they will give you a form, and sometimes they will ask you to provide, for example, like 10 or 15 years of your address history, employment history. Sometimes they do not do that, and they just tell you that the case is in admin processing. They don't need anything else. They just kind of like, they just need additional time to make a final decision. So in our experience, some cases are in the admin processing for 1 day. Some cases are in it for a week, but most cases really, get approved, or a final decision is issued in about 60 days. We have had, or we have heard of cases where the case is in admin processing for 1 to 2 years, but those are really, not that common. And really, like most cases, the admin processing does get resolved in about 60 days. There is not really much that can be done to kind of speed up the admin processing. You can send follow-up emails to the consulate, but really, that doesn't really speed up the admin processing itself. So what we have been seeing kind of more recently, or I would say that ever since COVID and kind of 2020, we have seen that more and more people, want to file change of status petitions with the USCIS. And this was especially the case, during COVID, where a lot of the US consulates abroad, they either completely closed, or they kind of limited the services, or visa services they were providing, and many consulates were just kind of not processing E-2 visas, or they just had limited staff, so it was just taking a really long time to get an E-2 visa interview appointment. So at that time, many people who were already in the United States on some other status, like, for example, B status, F status, H-1B, or really any non-immigrant status, they decided they do want to do the USCIS filings. So, the USCIS filings, as I said, you do have to be already in the US to be able to do a change of status filing. The petition is filed, it's a paper petition. It's filed with the USCIS. And one huge advantage of USCIS filings is that you can pay additional fee to the government. So right now it's $2,805. And if you pay this fee, then USCIS will make a final decision on the application in 15 business days. So in about 3 weeks. So it's a huge advantage, mostly for people, of nationals of countries where it just still takes like a really long time to get an E-2 visa interview. Then they do the USCIS filings under premium processing, and they get a decision in 3 weeks. And if they do get approval, that means that they can start operating the business, as soon as they get the approval. So when I said that the USCIS will make a final decision, so the final decision means that they can either approve the case right away. So in that case, they would issue you approval notice. They could also, just deny the petition right away. But in our experience, they really almost never do this. Like, either they issue a request for evidence where they ask you to provide kind of more documents, more information, or sometimes they issue notice of intent to deny, but really they never just, deny the petition right away. They would issue request for evidence, or the notice of intent to deny. And in both of these documents, if they do issue those, they would ask you to kind of provide more documents. And after you provide those, they usually give you 3 months to provide the documents. And after they receive it, then they would have another 15 days to make a final decision on the application. But yeah, ever since COVID, we have kind of seen increase in the USCIS filings. And I would say like even now, when almost all consulates are like back to processing times, like how they were before COVID, still, many people still prefer to do the USCIS filings. And then timings at consulates. So during COVID, as I mentioned already, many consulates like either like they completely kind of like like shut down for a certain period of time, or they were just kind of focusing on providing services to U.S. citizens abroad, and they were just kind of not really processing E-2 visas. Or they were, but because they had such limited staff, like it was just taking such a long time to get an interview. I would say that in our experience right now, most consulates are back to the processing times like before COVID. And then the processing times just kind of differ, each consulate, like it just, the timing is different. Some consulates, when you submit the petition, you could get an interview in about a month. Other consulates, like it will take much longer than that. So again, it's it's always good to consult this and kind of like with an immigration attorney, so you kind of know what timeline to expect. Perfect. So let's discuss some issues and complex areas for E-2 visas. So first, let's discuss the source and trail of funds. So this is, Jiyae mentioned this in the beginning. So when you are investing money in the US, the government wants to know what's the source of the money. And really, they want to see that the source of the money is legitimate, like the money doesn't come from criminal activity. And this is kind of the standard at US consulates, So like, for example, if the money comes from your personal savings from employment, at a consulate, what would be sufficient would be your personal tax returns, kind of reporting that income, and then you would just be submitting bank statements showing that you made the E-2 visa expenditures. For USCIS filings, like the standard is much higher, and the government, the USCIS, they just kind of like want to see much more documents about the source and the trail of funds. So if the money comes from your personal savings from employment, let's say that in the past 2 years, you save this money on your bank account, and then you are spending this money to make the E-2 visa investment, the government would want to see all those bank statements, like for the past like 1 or 2 years, and they would want to see that you accumulated, for every month, you would have to highlight like the payroll deposit. And then you would have to show that throughout the 1 or 2 years, you accumulated these funds on your personal bank account, and then you are using these funds to make the investment. So it's definitely, if you do want to do, if you are considering to do the USCIS filing, this is like one thing to keep in mind is, that the government will want to see kind of like this detailed documentation. And if you don't provide it initially with the initial filing, then they will definitely issue an RFE and ask for it. So I would say that sometimes, especially if the money is coming from, like, for example, like a sale of a house, you sold it 5 years ago and now you cannot get the bank statements anymore. This is one thing to keep in mind, that it may be better to do a consular filing if you cannot provide the documents, because USCIS will ask to see the documents. So now, are loans okay for, E-2 filing? So let's say that, you have a friend or a family member and they want to loan you money for the E-2 filing. Is that okay? So, yes, that would be okay. Any loan basically secured that is either unsecured or secured by your real estate property or is secured by your personal assets, all of those loans are fine. The only thing that is not allowed for loans is if the loan is secured by the E2 company's assets. So, in that case, the government would just conclude that, the money is really not at risk because, the money you are investing is only secured by the E2 company's asset and not your kind of personal assets. Another thing is, are gifts okay for E2 visa filings? So yes, the gifts are okay. But one thing to keep in mind is that you would still have to show, so like let's say that you have a family member and the family member wants to give you $100,000 to start the E2 business. You would still have to provide documents showing, the source of funds of the, like where the person who is giving you the money, how they obtain the money. So like, let's say that the source of the funds are personal savings from employment of the gift giver. In that case, you would have to provide the tax returns of the person. Let's say that they sold a property, then you would have to provide a purchase sale agreement. So you cannot really avoid, if someone is gifting you money, it would not be sufficient to just provide the gift letter. You would also have to provide documents showing where the person or what is the source of the money they are gifting to you. So small investment amounts. So this Jiyae touched upon this a little bit already. So this really kind of depends on where you are filing. So we consider, so generally any investment under $100,000 is usually considered to be a small investment for E2 visas. Some consulates are fine with smaller investments around $100,000. USCIS is generally okay with smaller investment amounts like this, but there are some consulates, as Jiyae mentioned already, for example, the US consulate in Tokyo, where that consulate is just kind of used to seeing much larger investment amounts. So if you come to that consulate and the investment amount is under $100,000, they may just consider and conclude that it's too low. So it's really important to kind of strategize as to, like, will you do a USCIS filing? Will you apply at a consulate? To see, like what would your chance for approval be with kind of the investment amount you have in mind. But as I said, generally anything under $100,000 is a small investment amount, and that makes the case usually riskier. But we do process a high number of cases where the investment amount is under $100,000. So now E2 visas for to investors. So we do get this question quite a lot. Is it okay for example, for you and your business partner, either from your home country or another country, or the partner is a US citizen or a green card holder? Is it okay for both of you to own the business 50-50? So let's say that you and your business partners are both, for example, nationals of Canada, and you own the E2 company, the US company 50-50. Can both of you apply for the E2 investor visa? So the answer is yes, it is possible. Just a couple things to keep in mind. So one thing is each of you would have to make the substantial investment in the E2 business. So and the investment amount should be kind of very, very similar. So it would not be okay if like one of you invested 150,000 and the second one would invest like 25,000. So that would be a kind of a red flag for a consulate. So each of you would have to make that substantial investment, and the investment amount should be same or kind of very, very similar. And then another important thing that we'll have to show in the application is that each of you will have kind of an executive or managerial role in the E2 company, and each of you will develop and direct the E2 company, because that's kind of one of the E2 visa requirements. So often in these types of cases, one investor is the CEO, the other one is COO, or it can be chief financial officer. Any role really on kind of like the executive managerial level would be okay. But each of you would have to have kind of, like different duties for the E2 entity, and each of you would have to hold that executive or managerial title. So what happens, if there are substantive changes to the E2 business after filing? And we can kind of discuss this, there can be either a change in ownership or a change in kind of the activities or kind of the services the E2 company is providing. So what happens if there is a change in ownership? So let's say, for example, that in the beginning you owned 100% in the E2 company, but later you sold 25 or 50% to someone else. Is this okay? So as long as you keep at least 50% in the E2 company, the changes are fine, but your ownership as the E2 investor cannot drop below 50%, because then you would be not meeting the E2 visa requirements anymore. And if you stay in the US, you would be violating your status. So this is extremely important thing to keep in mind, is that you always have to keep at least 50% ownership in the E2 company. Now, some consulates, they kind of require that if there is kind of a substantial change in ownership, they want to know. So for some consulates, like, you would have to send them an email, send them the new ownership documents. Other consulates, they will just tell you, this is fine, as long as you keep 50%, it's okay, and you will just bring the new ownership documents to the interview. Now, so what happens if there are changing services or kind of changing the services the company is providing after you got the initial E2 visa? So this will kind of depend on, like what is the change. So let's say that originally you got an E2 visa for a restaurant, and then in year 2 or year 3, you decided that you also want to do, for example, like a catering business or catering services, or you want to kind of start consulting to other restaurant owners as to how to increase, the revenues or something like that. So this change would generally be okay, and you wouldn't have to go back to the consulate or USCIS to get their approval to provide these additional services, just because those services are still kind of related to the original business idea. Now, let's say that you got the E2 visa for a restaurant, and now you want to start providing like IT consulting services or something just completely unrelated to the original E2 business idea. In that case, you would generally have to go back either to the consulate or USCIS, submit a new business plan and get their approval before you start providing those new services. So generally, if there is some sort of link between the original E2 business and the kind of the new services you plan to provide, that is fine. But if those two are completely kind of unrelated, then you would have to get approval from the government first before starting to provide those additional services. So then, are family business purchases okay? So here, there is no prohibition in the regulation that says that, for example, if you want to purchase a business in the US and your family member owns that business, like, that would not be allowed. It is allowed. It's what the concern of the government is that, they are concerned whether or not you are paying a fair market value for that business. So in these types of cases, if you are purchasing a business from a family member, it's always good to kind of submit additional documents, such as evaluation of the business or something from like a CPA as to kind of like how the purchase price was calculated based on the company's financials. Because, if you're purchasing a business for $50,000, but the business is worth 1 million, that's definitely a red flag for a government. So if you are purchasing a business from a family member, you would want to submit some additional documents, just kind of explaining how the purchase price was calculated, and that would conclude, this is a fair market value of the business, and then you paid that amount for the business. Perfect. So what are some common reasons for E2 denials? So one common reason is that, the investment amount is just too low. So for example, if you invest, $10,000, $15,000 in the business, and then you have additional funds on the company's bank account, but the only amount that was spent was $10,000 to $15,000. That amount is just too low at any consulate or even with USCIS. So that can be one reason for the denial. Another reason may be just nature of the business. So as we discussed, any kind of real estate E2 companies, as I mentioned, if the company only owns like 1 to 3 properties and is renting the properties only, and those would just not qualify for an E2 because you would not have any employees and the business would not really be considered to be real and operating. Another reason may be the filing location or venue where you file the E2 petition. So as we discussed, some consulates are just used to seeing large investments for E2. So if you apply at that consulate with low investment amount, they may just deny the application. Another reason for denial may be just the consular officer's concern whether the business will create jobs for U.S. workers. So you would, as Jiyae discussed, it's going to be really important to kind of submit a strong business plan that outlines the hiring projections. Another reason may be if you have issues with adjudicating officers. So, let's say that you applied for a student visa or B visa years ago at a consulate, and a consular officer, the interaction was not very pleasant or kind of friendly, and the consular officer leaves some notes in the system, and then years later you apply for an E2 visa, and the officer kind of like pulls up those notes, that may kind of affect the decision of the consular officer. And the last reason may be that you just didn't meet the requirements at the time of filing. So again, like if the investment amount is just too low, if you only invest around $10,000, then the investment is just not substantial. So yeah, that would be the last reason. You just don't meet the requirements at the time of filing. Perfect. And I know our time is up, so I'll just go through this very quickly. So what does it take to renew an E2 visa? So the two most important documents the government is going to look at the renewal stage are the W-2s for the past couple of years, and then the company's tax returns. So generally what the government wants to see at the renewal stage is that the E2 business has at least 3 full-time employees. And then, so salary doesn't really matter. So as long as you have 3 full-time employees, that is generally fine. Of course, it has to meet the minimum wage at the particular state. But for E2, if it meets it, the salary doesn't really matter to the officer. And then the officer is going to look at the tax returns of the company. So it's generally fine. And we do get this question often is, I submitted a business plan 5 years ago, and now the company's revenue, it never kind of like reached the projections in the business plan. Will the officer kind of like look at the business plan, and will they kind of question me why the revenue targets were not met? So it's generally fine that, the business plan, financial projections, like they are projections. So if you didn't meet them, it's generally fine. What the officers want to see is that the revenue was kind of increasing. So if you got the visa 5 years ago, you would want to point that the revenue was kind of increasing every year. But if you didn't meet the projections, that's usually fine. Sometimes what happens is that, the company, or this is also the case, during COVID, many businesses were not able to keep all the employees, and now many companies are renewing their E2 visas. And, so how do we kind of address this, that during a certain period of time, the company had to let go certain employees, or, what happens if the business is just not doing well right now? So in these types of cases, we try to still kind of like point to the fact that, yes, the business is not doing well right now, but in the past 5 years, the business did have employees, and the business does have, does plan to hire employees in the future. And we kind of try to explain, what the company plans to do to kind of increase the revenues, and how many employees they do plan to hire in the future. And the ownership, so we kind of discussed that already. So now let's get to the questions we received. So the first question is, I have in mind exporting from the US to one treaty countries. May I be eligible for this type of visa? So yes, so for the E-2, there would have to be an entity in the US. So you would have to set up a US entity. You would have to make the investment. You would have to hire employees. But yeah, like if the business is earning revenue, you are employing employees, exporting to other countries, that may qualify. Another possible option in this case may be an E-1 visa, because that is E-1 visa. It's a visa for treaty traders, and for that type of visa, there has to be international trade between the U.S. and a treaty country. And for that type of visa, one advantage is that you do not have to make an investment for an E-1 visa. The second one is that you don't necessarily have to have employees. So I just quickly wanted to mention that E-1 in this case may be an option as well. Jiyae, do you want to take?
Yeah, sure, I can do
one?
that. So I'm a TN visa holder. I'm planning to fund my spouse for this type of visa. So gifts are fine, right? So as Michaela also went through, when we're talking about the source of funds, what is important if you're using a gift? So the main applicant would be the spouse if they are going to direct and develop the company, right? But the source of funds need to be clarified. So if you're providing a gift to your wife, then you would provide the gift letter, and also provide evidence of where you earn the money from, that you obtain the funds to provide this funding. So gifts are okay, just remember to clarify the source of funds, and that should be fine with regards to the source of funds requirement. So can I apply for a change of status? I have a TD visa. That's another question that came in. Yes, it is possible to apply through USCIS for a change of status to E-2. Now, you should, so what you will do is you would prepare the application for, regarding proof of, the funds, proof of the investment and everything, and setting up the business and things like that. And you would you would submit an I-129 to the USCIS and ask for a change of status. And you need to do that within the validity period of your existing non-immigrant status. So that is possible here. Can my business partner be my daughter? So as we mentioned, there is a possibility to do the 50-50 dual investor type scenario. Now, however, though, both investors must meet all the requirements, and one of the requirements is also that the investor must develop and direct the business and make a substantial investment and things like that. So I don't, if your daughter is an adult and can do that, then that could potentially be possible. But keep in mind that each investor must meet all of the requirements. If your daughter is a minor, you can bring the daughter over under a E-2 dependent child visa. So that's another scenario. Do you want to take the next one, Michaela?
Mm-hmm. Yeah, so can I buy additional businesses once I start my initial E-2 business, even if these businesses are unrelated to each other? And if so, how can this be structured in the initial E-2 visa application? Yeah, so and kind of like always like purchasing additional businesses, like it's kind of like a really like complex, so it may be good to set up a consultation. But basically, if you already know at the time you are applying that, so the first thing to keep in mind is that there can only be one E-2 company. So like if you purchase additional businesses in the future, like it should be done under the E-2 company. If there are multiple companies, then it would have to be structured in a sense that the E-2 company would be providing management services to the other companies. So those are two options. But if you already know at the time of filing, like you plan to the E-2 company plans to kind of like run these different businesses, then it should be decided in the described in the original business plan. If let's say that you start with one business, and then you decide to purchase additional businesses, but in unrelated fields, and this was not kind of described in the original business plan, then you may have to go back to the consulate or to USCIS to get their approval. So it would just kind of depend on the timing and kind of like what is disclosed in the original E-2 visa application. Because and the reasoning for this is that, you know, if USCIS or if the consulate gives you approval for E-2 to run this particular business, like they do want to know if there is kind of like a substantial change or a significant change in the, you know, in kind of like what the E-2 company does. So that's kind of like the reasoning why they want the applicant to come back and get their additional approval.
All right, so there's more questions about gifting a daughter money to invest. So as we mentioned before multiple times, gift is fine for the source of funds requirement. Now, however, the investor, if the person is going to be the principal investor, they must also meet all of the other requirements that we described in the presentation, including that the investor must be able to direct and develop the business, and, you know, has the kind of the experience and ability to do so. So yeah, definitely a fact specific question. Definitely set up a consultation with us if you would like to, you know, parse out the details a little further.
And one other thing I wanted to mention. So if let's say that you will be the investor owning 50% and your daughter would be another investor owning 50, and you give her the funds, like what may happen in this case, because the government sometimes see this, if you are gifting her the funds, they may view it that it's really like your investment in the business and not hers, because you do own the 50%. So in that case, it may be better to structure it a little bit differently, or if the money comes from some other source.
Yeah, definitely. Can my spouse work at a different occupation on my E-2 visa? So when you apply for an E-2 visa, if you have a spouse, you can the spouse can apply for an E-2 spouse visa, and anyone who's on the E-2 spouse visa can work for any company they want in the United States. It's kind of an open work authorization. So yeah, it is possible if you're the principal investor and if your spouse is applying as an E-2 spouse, dependent spouse, then it should be possible for them to work anywhere. All right, so it looks like we have went through all the questions. Thank you everyone for your active participation. Thank you, Michaela, for providing your expertise. There's another question that just came in. Can you start making contracts with a B1 visa and then apply for the E2? That is generally fine. There are, you know, things that you can do as a business visitor, and meeting, you know, potential clients and doing things like that is included in the general, you know, things you're authorized to do on the B1 visa, and then you can use that to apply for the E2, but you cannot start working for your business until you do have that E2 visa and E2 status. All right, so thank you everyone. Thank you, Michaela, for sharing your expertise, and I hope everyone has a great day. Bye.